Let's say you have doubts regarding the legal aspects of an issue. What would you do? You'd consult a lawyer regarding the steps that should be taken next and decide how to move forward. But what would a man living in ancient times have done if he had faced a similar problem? Were there lawyers in the ancient world? Yes, there were. But the lawyers and the justice system in those days was not like how it is today. The legal profession is thought to have its origins in ancient Greece and Rome, though it hasn't always been welcomed by the people. During the second half of the 5th and the first half of the 4th century BC, the democratic people of Athens in ancient Greece thought that the professional excellence of a person was not only undemocratic, but actually anti-democratic. Thus, the orators were forbidden to take payment for pleading the cause of another. These orators were the earliest people who could be described as lawyers. To the eyes of the people, an orator was merely just a citizen helping out his friend for free out of his generosity. Only if they had let the legal practitioners practice freely and promoted the growth of the legal profession, Athens would probably have also developed a class of lawyers and jurists who could rival the great Roman jurisconsults and advocates. So, if you want to describe the lawyers as people who could practice the legal profession openly and legally, those lawyers were found in ancient Rome. Unlike Greece, in ancient Rome, the political profession was respected. By honoring the legal profession, the Romans were able to create a strong legal system which still survives to this day. The sacerdotes publici, known as public priests, were the masters of sacral and secular laws. They were primarily lawyers of the sacral law, but since sacred law frequently touched upon secular law or, at least, paralleled it, they also encroached on the domain of secular law. They had absolute knowledge of those laws and had the ability to interpret them effectively. With this priestly caste, began the legal profession of ancient Rome. However, not every priest was a lawyer or jurist. These lawyer priests were not basically just men of gods, but were of a noble birth, patricians, who were willing to assume important social and political duties. In short, they were wealthy folks born in a powerful family. These people were so popular and highly respected among the Roman community. The chief high priest of the College of Pontiffs and Roman politician, Quintus Mucius Scaevola, has stressed the importance of patricians being well versed in Roman law. It was a shameful thing for a patrician and a nobleman to be ignorant of the law under which he lived. The most important tasks of a Roman pontiff lawyer include declaring not only sacral but also secular laws, the issuing of special edicts, a practice which later was adopted by the Roman praetor, the giving of instructions as to how certain contemplated acts must be performed in order to be valid and binding acts, helping people draft documents, the handing down of opinions, or declarations on questions of either sacral or secular law, which was called responsa, and making sure the people subscribed to Mythical History channel with the notification bell icon enabled. The practice of giving responsa was probably the most important function of a Roman pontiff lawyer. It played a major part in the development and expansion of Roman law. These lawyers' role included giving advice to their clients on what to do and what to avoid regarding the matters of heirs, marriage, appointment of guards, adoption, and many others. Since people consulted these pontiff lawyers on matters of law, they were later given the name jurisconsults. During the middle period of the Roman Republican era, there was an ever-growing need for a variety of legal assistance in the Republic. So the lay people took it upon themselves to practice law. In the year 200 BC, these lay lawyers became outstanding and dominating in the matters of law. These legal practitioners also gained the name jurisconsults. During this time, various laws were constantly being created and modified. After 200 BC, pleading a case before the courts on behalf of a client was done mostly by the so-called forensic orators rather than by jurisconsults. The judicial magistrates, however, often relied on the advice of jurisconsults for providing certain instructions containing the pleadings of the parties as well as some definite directions as to what judgment should be rendered in case certain issues were found or not found. As the Roman territory grew further and further, the need for legal representation also grew. Not only because many ordinary people had little to no knowledge in matters of law, but also because a litigant might not always be personally present at the proceedings. He might be residing at a considerable distance from Rome and may have found it difficult to travel to Rome. In this, the Romans held a unique position among other ancient peoples who, as a rule, required that the litigant personally appear in court and plead his own case. Because among primitive peoples, no one was allowed to name another person to act on his behalf. Though ancient Rome had all these law experts, it didn't have a school or place of study specifically dedicated to law in the early days. And there was no requirement for them to obtain a license to practice law. So, from a technical point of view, Rome's legal profession was still at a primitive stage. At least the pontiff lawyers had those priestly colleges in which they learnt the sacral and secular law. They have also enhanced their knowledge by observing and learning from their better experienced colleagues. The lay lawyers also acquired their knowledge through the same method. Since the responsa were given in public, a common man who was interested in law could have attended the consultations and observed the experts, learning a thing or two about the legal profession from them. In addition to this, a learner of law attached himself to a famous jurisconsult, living with him and his family and sometimes also marrying his daughter. By following the jurisconsult closely, attending all the legal-related events with him and sharing some parts of his legal work, the law student absorbed the spirit of the Roman law. Like the people of today, not all the people of ancient Rome were interested in studying law. Only very few have devoted themselves to the subject. But as time went on, the number of lay jurists and lawyers became increasingly larger, and non-professionals began to concern themselves even with sacral law. As a result, the Roman legal profession expanded considerably but, at the same time, lost some of its original uniformity and cohesiveness. The pontiff lawyers slowly withdrew from practicing secular law. The lay lawyers abstained from pleading in the courts, leaving the job to the forensic orators. They only appeared in court on occasions like when a particularly involved point of law was raised, or when an especially important case was litigated, or when a notorious person was tried. In some rare cases, some of the renowned jurisconsults of Rome had the privilege to act as special judges or triers. Soon, even people from less wealthy families started to practice law. Since they had no political or social connections and were not rich, they started to charge fees from their clients for their efforts, unlike their predecessors who provided legal service free of charge. Thus, in the year 203 or 204 BC, a statute was enacted forbidding the charging or paying of legal fees to a lawyer. But this rule was frequently violated. The Romans called people orators who had a profession to speak in public, either in the popular assembly or in the Senate, or in the courts of law. But only a few of them have mastered law sufficiently to qualify as jurisconsults. Some others relied on the jurisconsults for advice regarding legal issues. The orators thought that it was unnecessary to study law and even regarded themselves as being superiors to the jurist lawyers. The term advocate or advocatus was first applied to the forensic orators of Rome in the time of the Roman statesman Cicero. Though, Originally, an advocate was a friend who gave his support to the litigant by appearing in court with him. The more the number of friends, the better. And if those friends were people of great importance, there was a high chance of the case turning in favor of the defendant. It is worth noting that Cicero was both an orator and a politician. He even became a consul, the highest magistracy in Republican Rome. He was the youngest man ever to attain that rank without coming from a political family. He insisted that this elevation was due to his success as a forensic orator and advocate. The orators adapted certain concepts and notions of Greek jurisprudence to Roman conditions. The Republican jurist lawyers or jurisconsults, on the other hand, took little notice of and showed no interest in Greek ideas or conceptions. During the early days of Rome, the orators had no certain time limit to speak at the court. Thus, they consumed more time to speak, taking 5 to 6 hours to end their speech. Later, a water glass was occasionally introduced to control the length of the speeches. The presiding judicial magistrate determined beforehand the amount of time he would allow for each side for speeches by measuring the amount of water in the glass or by fixing the size of the latter. Whereas a jurist lawyer's speech was always factual and brief to the point. The forensic orators weren't fans of the Roman legal profession. In fact, they did many things to degrade, despoil, and vulgarize the profession. In addition to this, the people's attention shifted from the jurist lawyers to the forensic orators. They would rather see and hear the verbal combat and dramatics of the forensic orators than a jurisconsult's responsa. The dramatics in which the forensic orators loved to indulge included personal abuse of the opponent or prosecutor, falsehood, distortion of facts and flattery, as well as the impassioned appeal to fear, resentment or sentiment. Thus, the assembly frequently seems to have judged a litigant based on the oratorical performance of his advocate or orator. So faced by the ruthless competition of the forensic orators and the public slowly losing interest, many aristocratic jurist lawyers gradually withdrew from the practice of law. Other jurisconsults, however, began to appear more often in court, assuming the role of advocates so that the ever-growing fame of the orators wouldn't outshine them. But the rhetorical talents of the jurisconsults were no match for the great forensic orators of Rome. In 52 BC, a rule was passed forbidding any person to appear on behalf of the accused unless he was a close relative. This was done since the practice of bringing friends to court was so much abused, to the point where people started hiring individuals to appear with them in court. But as one might expect, this rule wasn't carefully observed all the time. As time went on, the forensic orators also understood the importance of studying law, and so they did. Then they gradually became learned jurists. But that transition didn't happen overnight. The development took many years, and it continued even after Rome became an empire. This reduced the need for a separate class of jurisconsults in Rome. But what did a professional who had no complete knowledge of Roman law nor any oratorical skills do? With their knowledge of certain technical aspects of the law, they acted as legal draftsmen. They were called notaries, and their duties included drafting wills, conveyances, and contracts. As most of the notaries were barely literate and had no complete knowledge of Roman law, both the jurisconsults and advocates considered them as inferiors. Since the lawyers were forbidden to charge fees from their clients, Marcus Fabius Quintilianus, better known as Quintilian, argued that the clients could give money to the lawyers voluntarily as a gift. He also stated that he could not think of a fairer or more proper way of making money than through the practice of law, since, while doing so, he renders invaluable service to people in need. As the Roman Republic grew into an empire, there were high standards that needed to be met by the people before they could call themselves jurisconsults. The legal profession was highly supervised and his various duties were defined. The Emperor Augustus had devised a system by which certain lawyers were granted the privilege of giving opinions publicly on his authority. In other words, only those jurisconsults who had received a special imperial patent were now permitted to give authoritative responsa. Those jurists who were outstanding in their work were promoted to the highest administrative or judicial office throughout the empire. Under the tyrannical rule, the orators have lost their prominence and fame. Finally, Emperor Claudius, in his reign, banned the ban that banned lawyers or advocates from charging a certain amount of money as fees for their services and also legalized the legal profession.
It's law. Roman law.
Is there some other form of law?